meeting to order. Let me go through the roll. Andrew, are you here?
Andrew is a couple of minutes late, Drew. He just came back from a call.
Great. Sunita, are you here?
I'm here.
Great. Howard, are you here?
I'm present.
Thanks, Howard. Ashfar, I saw you. You're here, right?
Yes.
Great. Dick, are you here?
Yes.
Great. Franco, how about you? Franco?
Franco's here.
Oh, great. Thanks. And Dave,
Yeah,
that's
I'm here.
you, right?
Yeah, that's me. I'm here.
That's great. And I'm here, Chair Lanza. So we've got 7 out of 9. Again, for the record, no, we've got a vacancy after Vince left. We usually go through formalities. With any luck, this will be our last Zoom call, and either next month or June we'll start meeting again in person. I'm sure Roberto will talk to that in his section. We don't have to waive sunshine on anything, and we don't have a closed session, so we can go directly. Does anyone want to pull anything off the consent calendar? If not, I'll entertain a motion to approve the consent calendar.
So moved by Santos.
I have a motion by Santos. Do I have a second?
I'll second it.
I have a second by Ashfar. Let's go around the room. Sunita, how do you vote?
Aye.
Howard?
Yes.
Ashfar?
Aye.
Dick?
Yes.
Franco?
Aye.
Thanks. And Dave?
Aye.
I'm Chair Lanza. I vote aye as well.
True.
Zooming through this.
True.
Investments, over to you, Prabhu.
Great. Thank you, Mr. Chairman. We have a very short agenda on the investment side this morning. But before I get to that, I do have pro forma performance. And as of April 5th, fiscal year to date, the pension plan's up 1.79%, a slight improvement over last month's 1%, and the healthcare trust is down 1%, also a slight improvement over negative 1.6% last month. And these are, of course, unaudited estimates from Makita as of April 5th. The market does continue to confront a host of issues, including inflation, geopolitical risks, and Fed actions. And it'll be interesting to see what happens over the next few weeks before the end of the fiscal year. We do have one item for the board to discuss and take action on, and that is strategic asset allocation for the healthcare trust. We usually follow the pension plan SAA with a look at the healthcare trust and suggest changes, if any. We did have a chance to talk to the IC chair, Trustee Menon, about this, and he made some recommendations and suggestions, and we've come up with one mix that we'd like the board to consider. And of course, I'm always looking for feedback from all trustees. With that, I'm going to turn this over to Laura Wyrick of Makita to talk about the SAA for Healthcare Trust.
Good morning, everyone. I'm wondering if there's someone on the investment team who might be able to share the document. I'm having some technology sharing screen issues I'm working on.
Okay.
I can also keep trying here. When I download it from the website, it's not working in my.
Laura, if you give me a sec, I'll pull it up, and if you could just direct me, we'll go through it.
That would be great. Thank you so much.
Thanks, Michelle.
Just to sort of lay the groundwork while we're pulling the document up. So as we discussed when we talked about the pension asset allocation, there were some prior years where we adopted a new asset allocation for the pension and didn't quickly update the healthcare trust analysis. We think it makes sense to have the same sort of strategic sort of philosophy for the healthcare trust, even though, as you all know, the healthcare trust cannot invest in illiquid assets. Also, a difference historically, if we want to go to the introduction page. Historically, the healthcare trust sometimes had the same actuarial assumed rate of return, target return as the pension. but that has changed in recent years, which is more consistent with what we see for other institutions. And now the expected actuarial assumed rate of return is 6%, so lower than that of the pension. The good news is that the healthcare trust long-term expected rate of return that we expect based on our 2022 capital market expectations remains above that 6%. So there's no need to make a change in asset allocation based on, a lower probability of hitting the expected return. However, we wanted to offer you an additional scenario to take a look at for comparison in case you did want to make some changes similar to those that have been made in the pension. So if we want to skip to page 3, we've talked about this chart before, but the basic message is that your job is harder than it used to be, as you know. So we can go ahead here. Let's go to the slide that compares the different asset allocations. 2 more, I believe. There we go. Oh, back one. Thank you very much, Michelle. Okay, so we have here the comparison of your healthcare trust current allocation in the left column compared to Mix A, which is the other one that we worked with your internal investment team and the chair of your investment committee to develop. We also compare it to a 60-40, 60% global equity and 40% investment grade bond allocation as well. And if we take a look at the bottom here, you can see that the Makita expected return for 20 years, which is what we prefer to focus on in the long term, remains at 6.4% for the current allocation and also is the same for Mix A. However, the difference here, if you take a look at Mix A, is that the standard deviation or the volatility is lower for Mix A. And you can see that the difference here is mainly that you're taking money out of emerging markets equity. So you can see that emerging markets equity right now, you have a 15% allocation. When you look at Mix A, we've lowered that to 12%. And that 3% that we took out, you can see 2% went to developed markets equity and 1% went to short-term investment grade bonds. We've talked about with the pension, as you all know, short-term investment grade bonds will be less negatively affected by rising interest rates than traditional investment grade bonds. If we skip ahead to the scenario analysis and the risk, actually let's stop here on page 8. Page 8, you have the peer allocations. And as we've discussed, most funds that have a health and welfare trust are investing in a much more conservative fashion than their pension. So you can see here that the median total equity allocation for peers is 27%. So you all in the healthcare trust have a much higher allocation to equity, mainly because you have a situation where you have that 6% actuarial assumed rate of return. The next slide. Here we have the mean variance optimization based risk analysis. You can see that there's not a huge difference here between the healthcare current allocation and Mix A. Mix A, given that lower volatility number that we just talked about, would be a little bit less likely to experience negative returns or have as much of a negative return for these different time periods that we're looking at. But the probability of achieving at least a 6% return would be very, very slightly lower, not anything that we probably notice a difference on in the real world. Taking a look at the next slide, in terms of the negative scenarios, we look here at things like the global financial crisis. Mix A would protect a bit in those scenarios. And then on the next slide, we look at positive scenarios historically, and you would have up returns that are very close to what the current is. Actually, if we could go back one slide to slide 10, let me just point out here stagflation. Stagflation is something that we haven't seen since the 1970s, but that's a scenario where we have inflation but low growth, which is a very difficult environment for assets to, for financial markets to have a positive return. Not a huge difference here between the current allocation and Mix A, but you would see some protection from Mix A in a stagflationary environment. And then also the rate spike, the 1994 calendar year. We don't have too many historical scenarios where there's been a rate hike, but you would see slightly higher returns for Mix A here. Going ahead 2 slides. We have stress testing here, and I'll just mention that, in a broad equity market decline, you'd still see negative returns across the board. However, Mix A should protect a bit. And looking at page 13, we see positive markets, and again, not a huge difference here, but Mix A would be slightly behind the current in a strongly rising environment. Economic regime management is the next section. A couple pages ahead, one more please. Here we see systemic risk is the biggest risk to the portfolio. This is like a global financial crisis type environment. And you can see that the current and Mix A are quite close together in terms of how they would return. So moving ahead to the summary, as I mentioned, you did update this asset allocation relatively recently. It is still expected to outperform your actuarial assumed rate of return. And so we don't think there's a major necessity to make a change, but we also think Mix A is quite reasonable. So I'm happy to take any questions.
Michelle, can we go back to slide 7, if you will?
Thanks, Laura. You want to drive for a while, Prabhu?
Actually, it's 6, I believe. Okay, thank you. Yeah, thank you, Mr. Chairman. I believe the current allocation, as Laura mentioned, it looks fine, but we did discuss internally within the investment team along with IC Chair Trustee Menon, and we made a couple of tweaks. We actually run a bunch of scenarios, and Mix A seemed like a good alternative to the current mix, where we get the same or slightly higher return or about the same return with lower risk. So we're happy to take any questions on any of the changes, but we'd like the board to consider either the current allocation or Mix A.
Hey, let me go first, Laura. Sort of on a philosophical level, we said, remember going back, Laura, that we would pick our discount rate both sort of grading on a curve and absolute. So grading on a curve, we said, well, we should be probably slightly below the median of our peers. And absolutely, we picked that 12% ball number. And you've now said, Laura, well, look, these asset allocations meet the vol number. I can tell you that we are below our peers in setting our discount rate. You guys showed us that last month. But you said, Laura, the expected return is still higher than our discount rate. I don't mean to put you on the spot, Laura. Does your instinct, Laura, tell you we should maybe slightly raise our discount rate, or does your instinct say, nah, just keep it where it is? Do you have an answer to that, Laura?
That's really an actuarial question, and yeah, I hate to infringe on Bill Hallmark's expertise. I would say 6%, if we were to look at it in the range of other health trusts, is still on the higher end.
Okay.
This is my understanding is this is a pretty well-funded plan, given its sort of immaturity and how much folks are paying in. That would be Bill's expertise more than mine, but the 6% I think is still on the upper end of what you see with peers.
That exactly answers, as always, Laura, you're thorough and very well thought out. That exactly answers the question. Hey, floor is open. If anyone wants to ask Laura or anything, go ahead and jump in.
Yeah, Drew, Dick Santos.
Yeah, go ahead, Dick.
Yeah, thank you, Mr. Chair. Laura, I know this is the number one question. With the war going on, is everything more at risk, more volatile? It's obviously things that can't be stable and no one can predict. And so any comments, I get these questions all the time and I don't have the answer. I'm like everyone else. I wish it wouldn't happen and I wish everybody was safe, but it's a tough time. And I'm sure in the investment world, it's very iffy.
Yeah, you're right. There's certainly even more unknowns than there have been in recent years, given war and inflation as well. We, like you said, it's very difficult to predict how things are going to go. It seemed like a global pandemic should have depressed returns and did not. And our institutions that did go more conservative because of that situation, missed out on returns. So we try not to make too many short-term tactical moves. That said, you do have in your current allocation a high emerging markets equity allocation. And it's 15% of the portfolio being affected by moves in emerging markets is probably on the riskier end. So I think it's reasonable to consider mix A and lowering that emerging markets equity allocation.
And thank you.
Yeah, I have a question. This is Sunita.
Jump in, Lisa.
So, I mean, I was trying to desperately pull up our the pension plan asset allocation we approved, but my recollection was we went almost to zero on long bonds, and you really shortened duration, Prabhu, or V, I should say. So I don't know, what was the logic in keeping long-term bonds at 5% in this portfolio? I thought it was a good call, by the way, but.
It's always a trade-off between protecting the assets relative to worrying about duration changes and whatnot. So, excuse me. That is a change that we considered here as well. Given that you have no ability to invest in private debt and some of the private assets in this plan, there's not a lot you can do to sort of protect against equity market downturn risk. And long-term government bonds historically have been the only positive asset class when you've had major equity market drawdowns. Of course, now we also have a different interest rate situation than we have in some of those scenarios, but you're now at, I believe, 3% on long bonds, or maybe down, 1.5% on the new pension asset allocation. But once we sort of gross up all of these numbers for the lack of private markets in the fund, this isn't a vastly different percentage.
Yeah, that's exactly it. We figured that long government bonds are probably the only asset class here that can act as a diversifier. And so hence despite all the headwinds that fixed income faces, we thought we'll maintain that weight.
Fair point. So where is the 3% reduction in EM equity going?
2% to developed markets equity and 1% to short-term bonds.
Yeah.
So the additional percent to short-term bonds is sort of a recognition of the interest rate environment.
Mm-hmm. Yeah, makes sense. Okay, yeah, I think I'm supportive of mix A.
Floor's still open. Anybody else want to jump in?
Yeah, Drew. So just I echo what Laura and Prabhu said, and agree with Sunita. I think the thinking when we discussed this was, we moved in a certain direction in the fund, and maybe we should do the same thing. And personally, I think for emerging markets, compared to a few years ago, I see more risks than there used to be, and I think it's these geopolitical things which didn't exist. So even though ex ante the returns look better sometimes, they realize it's really not paid out, right? So ex post returns have been lower with the additional risk, and I think so lowering the risk and not really giving up much in terms of expected returns. I think mix A, I would say, is a good choice for us.
Anybody else want to weigh in? Hey, Ashwar, why don't you go ahead and make the motion? I think you almost just did.
Yeah. Okay, so I move a motion that we move to mix A for the healthcare trust.
Do I have a second? I have a motion by Ashwar and a second by Santos. Let the record show. I think, Andrew, you're here now, right?
Yes, I am.
How do you vote?
Aye.
Sunita?
Hi.
Howard?
Yes.
Ashwar?
Aye.
Dick?
Yes.
Franco?
Aye.
And Dave?
Aye.
I'm Chair Lanza. I vote aye as well. Hang on, let me flip back to. So I got a note from Roberto. I think you're right, Roberto. It's kind of a function of the way we organize our agenda that we break out old business items into category number 3 and new business category number 4. But as Roberto wisely pointed out, sometimes items and the felony forfeiture is an example of this, are both old business and new business because we're continuing something we started and there's something new we pick up. So Roberto suggested that we put together items 3A and 3C, and then after that, items 3B and 4D. So I guess, Roberto, do you want to jump in and drive 3A and 4C? Do you want to make any prefatory remarks?
Yes, thank you, Mr. Chair. So yeah, my suggestion is to have the discussions right after the other because they are related items. So as you indicated, Chair Lanza, 3A, which is the revised valuation results by Chiron, to be discussed sort of in conjunction with the Segal audit on, again, on the OPEB evaluation report. And in fact, I think some of the changes on the report by Chiron, which is stated in the new revised report, if I'm mistaken, Bill, please correct me, are a direct result of the suggestions or the discussions with Segal on the audit. Second, I do want to thank Bill. He enjoys this meeting so much that he is on vacation in Hawaii, but this say he wasn't going to miss this for anything. So he's here with us this morning. I suspect a little earlier in Hawaii time. And so I'll turn that over to Bill so he can make any comments that prepare statements regarding the revised OPEB valuation result. And then after that, Mr. Chair, I think, granted, if there are any questions, they can be discussed, then we can turn it over to Segal for their presentation on the audit results for the OPEB valuation report. Thank you.
Good morning, everyone.
So Bill, what island are you on? We're entitled to ask. Where are you?
I'm on Kauai.
All right, we're all jealous. Go ahead, Bill.
So the reason for this revised report is that there were about $3 million in benefit payments for fire members that were charged to the police accounts. And so Benji provided us with some revised asset statements that corrected that $3 million. And so we just wanted to issue a revised report to get everything in the right buckets. It does not change the overall numbers at all. It doesn't change the liability numbers at all. Doesn't change the overall city contribution, but it shifts it shifts about 3 million of the assets from fire to police. And so it reduces the city's contribution to the police fund by about $60,000 and increases it to the fire by the exact same amount. So that was the substantive reason just to issue the revised report to reflect the corrected assets that were provided to us. It doesn't change any of the liability numbers that Segal reviewed. But as Roberto alluded to, we had already Segal's report on the federated OPEB, and they had made some recommendations on disclosures, which we anticipated they would make on the police and fire report as well. And so we went ahead and enhanced some of the disclosures in accordance with their recommendations and changes we made on the federated side as well. I won't go into those. I'll let Andy do the presentation from Segal, but I think they're good changes to the disclosures in the report. So with that, I'd take any questions on the revised report.
Floor's open. Any comments? Roberto, if you want to jump in, any comments?
Yeah, no, I just want to first thank Bill for providing the detail behind the revised report. I want to thank the staff and Chiron for working throughout the process, and obviously Segal as well, working with Chiron and staff during the audit work. And I just want to also mention to the board this issue about the mishap between the police and fire funds were actually stated or raised at a prior meeting. And so staff is already working on the requirement changes, not only on an accounting standpoint, but also from the legal standpoint. So we are having conversations with counsel make sure that everything is correct. But I think as Bill indicated, it's not overstating, understating the liabilities. It's just making sure that they are recorded in the right section, right? What is fire to be fire, what is police to be police. So with that, again, we're happy to answer any questions.
Any other questions? If not, we'll go to Andy.
Well, we need to
Question.
Oh, we need to
we
vote
need to make a
first?
motion by the board
Okay.
to approve the.
Harvey has his hand up as well.
Oh, yes, sir. Jump in, Harvey. Go ahead.
Yeah, no, just a clarifying question, Bill. Is the adjustment being made on the books of the 115 trusts or in the 401H accounts?
The change was made in the 401H account. There are some details to that that don't really matter for the valuation, where the valuation is based on the total assets. And so, but internally, we made the change to the 401H account assets. That's where the benefit payments had been made. But there is the issue of tier 1 versus tier 2 in the fire, but that issue does not affect the valuation at all.
Okay. Thank you.
Any other questions? Floor's open. Thanks for reminding me, Roberto. If not, I move that we approve and accept the revised OPEB valuation results. Is there a second for my motion?
Second by Santos.
A motion by Lance, second by Santos. Go around the table. Andrew?
Aye.
Sunita?
Aye.
Howard?
Yes.
Eshvar?
Aye.
Dick?
Yes.
Franco?
Aye.
Dave?
Aye.
And I'm Chair Lanza. I vote aye as well. That was item 3A. For those of you just joining us in progress, we're going to skip forward to item 4C because we've got Andy Young from Siegel here. So Andy, you want to take us into item 4C?
Yes, thank you so much, Chairman. This is Andy Young. I'm joined by my partner, Sam Bostani. We're here to present to you the audit findings from the June 30, 2021 audit report. So with that, I'll just share my screen. I have the evaluation report, the audit report pull up. As you can see from the page 1 of our audit report, this is really a very clean audit. I'm trusting that you can see a copy of the report, page 1, right? Just want to confirm.
Yeah, we can see it, Andy. Thanks.
Okay, thank you so much. As we have indicated, the most important reason why you want to do an audit is to make sure that we can confirm the results of the actuarial valuations prepared by Chiron based on the June 30, 2021 membership data as well as financial experience. And then for that, you have received the good clean bill of health from Siegel. I have to mention though that as part of this audit, we were still looking at the results from the report dated January of 2022. So in other words, even though we have not looked at the revisions that the board has just approved, but we nonetheless agree that it really have no material impact on our audit findings, because in a lot of other places in our valuation audit report, we tend to be looking at the financial system, the valuation benefits, as well as the actuarially determined contribution for the system as a whole. So even though there have been small shift in assets between the police and fire, nonetheless, it really does not change our audit findings. Now that we have gotten the clean bill of health from the auditor of the auditing actually out of the way, we do notice a couple of small improvements that Chiron and the board can consider for the next actuarial valuation coming up in 2022. That has to do with the fact that in the audit, we noticed that there are some tier 1 and tier 2 members that are currently enrolled in and covered by the VEBA trust. And those are the members who would be expected to get a catastrophic disability benefits. So our understanding is that when those members retire, they would be eligible to receive a maximum health subsidy based on what would be required to provide the members with a single party premiums under the health plan. And we confirm with Chiron that instead of using the single party premium cost, for those members who are expected to be married, they have actually pick up a slightly higher premiums corresponding to those who are married or those with a family coverage. We don't think that it is a material change, but nonetheless, we want to point out to the board that there's a slight overstatement in the present value of benefit and therefore the actuarially determined contributions. So those amounts, again, not very big. On a present value basis, we're looking at about $6 million. And on a actuarially determined contribution basis, there have been some slight overstatement of about coming in about $580,000. And then a percentage of payroll basis, about 0.22% of pay. So if you keep all these amounts in mind, when you go through and look at the rest of the report, it more or less explains really the difference between Chiron's results and Seagull's result. And again, we don't think that this is something that is worth revising the report, for example, for that matter, but definitely something that we would recommend that Chiron take into account when they develop the liability and therefore the contribution rates in the next valuations process. So other than that, we talk about the actuarial assumptions that we have basically pick up and utilize in the valuation. And we have not been asked to take a look at the non-economic assumptions. So that would include, for example, how old the active members are when they retire from the plan and how long the active members would live after they start collecting a benefit. But as part of this valuation, we do have taken a look at the healthcare related actuarial assumptions. So again, towards the end of the presentation, I'm going to turn to my partner, Sam, and ask him to share a couple of findings and observations with you. So now I'm going to just jump to the towards the end of at least the part of my presentation. I want to again show the board how close we are to matching the present value of benefits. So this would be the amount that, if available on hand, would be sufficient to pay for all the benefits. So using Chiron's numbers, and again, this is not impacted by the revision of the assets as Bill Hallmark has indicated. They have come up with a liability, a present value of benefit of $850 million. Seagull's numbers was $841 million. The difference is $9 million. And out of this $9 million, as I've indicated, 6 million of those numbers can be explained by the difference in the catastrophic disability benefit that I was talking about early on. And then we also mentioned in this report that our actuarially determined contributions were coming in at around 97% of the number that Chiron has indicated. So in dollar terms, I just want to go to this page before I turn it over to to my partner, Sam. So the contributions that we have calculated, so I'm going to cheat and look at the paper copy, 18B. Just bear with me when I turn over. Okay, so the contributions that Chiron has calculated in total for the plan, again, not impacted by the revised assets, coming in at about $29.1 million. Seagull has come in at $28.4 million. So the difference between the two numbers, about $700,000, and of which about $580,000 could be explained by the variance due to the disability, the catastrophic disability benefit that I just talked about. So I think with that, why don't I just stand over to Sam, and maybe have Sam, you can walk us through some of the reviews that you have done specifically on the healthcare related assumptions and items of notes in reviewing Chiron's valuation report.
Sure, thank you, Andy. So Andy, good morning, everyone. Andy, if you can just please go back to page 14. Okay, so I'm just gonna quickly talk about the healthcare assumption that were used in the Chiron report 2021 here. I've mentioned this, I've discussed this when we presented on the Federated, so these are similar notes and comments. So on the claim costs, the claim costs were based on fully insured premium charged to the city, and the claim costs were developed using combined data for police, fire, and the Federated employee, which makes sense given that all these groups are underwritten together. Pre-Medicare claim costs also were loaded for child costs. The claim costs were developed separately for pre-Medicare versus Medicare. Age adjustment were introduced to age adjust the premium. So all these are really in accordance with actual standard practice. So we do believe that the healthcare cost methodology assumptions are reasonable. The second item is the healthcare cost trend assumption, and we do also believe overall they are reasonable. Typically, the assumptions start by short-term trend rate, which are typically a projected near-term experience. Then they do grade down over time to an ultimate trend rate, over a long period of time, typically. The trend assumption here were developed using the 2021 Getson model. This is a very common model, used by many practitioners out there. The initial trend rate for pre-Medicare was 8%, for the Medicare 4%. Again, all this stuff are within ranges used by most firms, including Siegel. However, the ultimate trend that I mentioned is 3.78%, and happened to be a little bit on the low end. Based on our experience, low end trend for most firms that we observed are within the range of 4 to 4.5%. Having said that, we do believe that the assumption overall, trend assumption are reasonable. Any question on the healthcare assumption review before I move on?
Thanks, Sam. Anybody got any questions for Sam or Andy?
Yeah, Mr. Chairman, maybe I didn't hear it properly. This is Santos. When it down at the bottom, when you said it should be 4 to 4.5%, how does that get there as opposed to the 3.78?
Well, it's I don't think we're saying it should be. I think what we have been observing is for many firms and practitioners, a ultimate trend to be between 4 and 4.5%. The Chiron is using a lower end trend. Again, I don't think it's a concern. It's just an observation that we're making here.
Was there a better method or a better process to do to make sure that can be attained?
I guess it's maybe Bill, you can talk about how you develop.
Let me just clarify a little bit what's going on here. So this Getson model is a standard model that's published by the Society of Actuaries, and it has a baseline set of assumptions. On the ultimate trend, one of the key components of that is the price inflation assumption. And we are using the 2.25%, which is the same as what we use for the pension plan. Their baseline assumption is 2.5%, which would increase you by 25 basis points from the 3.78. And so that's the current difference. And I do think, given where inflation is now, this is something that we will be reviewing the next time we do the economic assumptions. And so it would affect items in the pension valuation and the healthcare valuation going forward if we change the price inflation assumption. But we will certainly be reviewing that with the next review of economic assumptions.
Thank you, Bill.
So mortality, Bill, you and Siegel line up on mortality overall pretty much?
Yeah, I don't think they had any comments on the mortality.
Yeah, just the cost of those who live that's unknown. Okay, great. Andy, any other questions? Any questions from the public?
I have one question, or one thing I want to highlight to the board.
Sure.
Please go to page 6 of the Siegel report. Thank you. Here it has a recommendation that the board consider the pros and cons of whether or not to use a 5-year smoothing amortization or to keep with the market value of the assets. I just note this here for a future presentation for the board to consider, since it is Siegel's recommendation that we consider that and have educational piece on it for a future agenda item.
Oh, great. Thanks, Maytech. You guys can pick that up. Floor's still open. Anybody public? If not, we'll go back to you, Sam and Andy.
All right, so if we go back, I'm gonna quickly just go over page 15. I'm going back to very quickly items of note. Just some comments here and observation again based on a discussion with Chiron and then some finding, look at the report. Again, similar comments we had when we presented the federated audit. The cost trend is disclosed in the report on a calendar year basis. Between the valuation is on a plan year basis, July 1 through June 30. So what we are kind of suggesting here is for better transparency for readers and users, so maybe kind of disclose the trend assumption on a plan year basis. The second item quickly is the in lieu assumptions on the page 49 of the report. The report disclosed that the amount of the in lieu credit is based on tier of coverage. And so what happened is, we needed to kind of rely on other documents and discussions to kind of understand how the credit amount is determined, which happened to equal 25% of the subsidy for the coverage, the retiree that qualify for. What we're suggesting here for Chiron is kind of clearly disclose this information in the report. On the VIBA and the service-connected disability, Andy touched on early. The VIBA members on service-connected disability receive benefit from the healthcare plan once the VIBA funds are exhausted. The report doesn't address how the funds are built up. I think we understood based on other information that the members' contributions are based on higher tier. What we do suggest kind of add this information clearly in the report. Also, the report is not explicit in respect of how the VIBA funds are drawn down. Again, I think this should be disclosed clearly in the report as well. Chiron confirmed that the maximum subsidy amount under the catastrophic disability for the VIBA should be valued as a single coverage premium. That was discussed by Andy earlier. And we understand that Chiron will reflect this change in the next valuation. The other item to note very quickly is disclosure for different spouse assumption for some various benefits. We do suggest these to be more explicit in the report. For instance, the spouse assumption medical versus dental. And other observation, next one is we just noticed, look at the report, not the revised report, I haven't looked at this one yet, that there was some inconsistency between some of the numbers. I'm just giving an example, member counts on page 23 doesn't match a lot of member counts on page 35 and so forth. So what we're saying is, we suggest that Chiron address those inconsistency and to prevent confusion in the next evaluation. So these are the item of notes I wanted to kind of go over with the group here. Any questions?
Yeah, floor's open. Any questions for Bill or Sam or Andy? Anything from the public for Bill or Sam or Andy? So Roberto, I think Maytac really hit, good job Maytac, hit a nail on the head. So there's really two steps here, right, Roberto? One is to accept this, and we're about to, I'll make that motion in a minute. But the other, I suppose, is, Roberto, for you and Bill to sit down and maybe at the next board meeting, the June board meeting, kind of do what Sam just did part of, and kind of go through the places where the audit suggests, as Maytac said to the board, maybe they should consider discussing with Bill a change to current practice. I assume, Bill, you would not suggest we change everything that Siegel has suggested here. These are debate points, right?
Well, I think I haven't gone through the inconsistencies that they identified, but the other disclosure items we reflected in the revised report because those are the same comments they made on the federated report, and we agreed that those disclosures could be improved. I think there's one, the change to the catastrophic disability we agree with, and we agree that it should be reflected in the 2022 report. The issue Maytac raised, we agree that we should revisit that with the board and review that that part of the funding method, but our recommendation will be to continue what we have.
Yeah, that's what I thought it would be. So Roberto, how about next meeting or June, you come back, just as Bill did verbally, with a list of, here's what's in the actual report, and Chiron says, yep, let's do it, or it's already been done in the revised. And here's some stuff the board, as Maytech said, should dig into maybe and learn more about and noodle over with Bill. Can we do that, Roberto?
Yes, certainly we can. I'll reach out to Bill and we'll get back to the board, whether it's the May or the June meeting. And I'm fine. I think we were planning on doing so anyway. My only question to Bill will be, I think certainly we can do it now because it's fresh on everyone's minds. Usually, I think in the past, what we have done is, as we kick off the actual evaluations process in the fall, that's when Cairo will bring some comments as a reminder so that they can bring you up to date. But we certainly can do it sooner than that. Is that okay, Bill?
Yeah, that works fine. I do think the issue about the amortization and asset smoothing for the OPEB might be good for a separate educational session, just so we can go through all the background and the pros and cons of the different approaches.
Certainly, and I agree with that. And I think that one, I think we both, I don't want to put words in your mouth, but I think that make more sense to do it closer to the kickoff in the fall, so that is fresh in everyone's minds when they start making those choices for both evaluations. Does that make sense?
Yeah.
Okay.
So
yes, we will do that.
Great. So in that case, let me go right. And so let me go and make the motion then. I move that we accept Siegel's actuarial audit, and would note that there are a few items in there that we are going to continue further discussion on, and we may accept their suggestions or deny them. But Bill's going to help and Roberto lead us through that. So I move that we accept the audit. Do I have a second for that motion?
Second from Santos.
Great. Motion by Lanza, second from Santos. Round the table, Andrew?
Aye.
Sunita?
Aye.
Howard?
Yes.
Eshvar?
Aye.
Dick?
Yes.
Franco?
Aye.
Dave?
Aye.
I'm Chair Lanza, vote aye. Hey, Siegel Chiron, absolutely fantastic work of the highest order. Thanks, Andy. Thanks, Bill. Thanks, Sam. This is really helpful, and it's good. We're going to talk about smoothing, Bill. I know it's a subject that comes up over and over again. We're probably due for another review of that. Bill, go enjoy Kauai, and Andy and Sam, you're not in Kauai, but I'm sure you wish you were.
Yeah. So
Thanks,
I know that we say that multiple times in our report, but again, I want to the record to reflect that Siegel thanks Chiron, Bill Hallmark in particular, and also Roberto and his staff for all the cooperation and assistance we have received during the audit. So thank you so much.
Thank you so much, Andy. All right.
Thank you, Andy.
Great. Okay, you guys can sign off, Bill. Now, we're going to be moving on now to the felony forfeiture stuff. I'm going to turn it over to Maytac in just a minute. But before that, let me get it. So you're there. Hello, greetings from Austin, Texas. Hey, let me drive the screen for a minute. Will you, ladies? You can take the agenda off. I'm going to just make a couple of preparatory remarks. So the old Italians have a saying. I'm 23andMe says I'm 97% Italian, so I consider myself Italian. And the saying, I forget what it is in time, it says, don't get ahead of the pasta. And what that means is you put the pasta in the water, boiling water, and that means 7 or 8 minutes before dinner. And there's this instinct to put the dinner on the table when the pasta goes in. And the saying is, no, wait a minute, hang on, you got 6, 7 more minutes. Don't pull it out of the oven yet. So I think that's kind of a theme for what Maytac's going to say is, let's all be real conscious of where we are in this process, right? So I would say a couple of preparatory remarks, and I've got a little chart I just created, I'll put up. So first of all, look, with tremendous authority comes tremendous responsibility. You've all had a chance to read what's in the San Jose City Code. As it comes to felony forfeiture, and Maytac rightly points out, we've been given an enormous amount of authority. And so as Maytac has almost been working on this for a year now, we are going to exercise an enormous amount of proper responsibility as we look at this. It's been a year in the making. It has been literally dozens, if not hundreds of lawyer hours by Harvey and Maytac, mostly by Maytac. All parties have been looped in. That's part of the reason why it took so long. And the key part of responsibility, you can see it in everything Maytac does, is this notion that we make absolutely certain that we grant all the constitutional, both US and California rights of due process to the folks we'll be discussing. Now, the idea, I'm going to put a little chart in just a minute. I want everybody to think of the words can, should, and will. What can we do? What process can we run? What should we do? What process should we run? And what will we do? There will be a motion made at the May board meeting, maybe the June board meeting. And what will we do in terms of process, right? Let me see if I can show you this little thing. I just made this up, so let's see. Let me see. Well, I can't show it right now because I'm on my iPad and not. Yeah, it's fine. Hey, so right now today, there's the actual hearing. We'll decide what we should do with the pensions of these folks that have committed felonies. We're not going to talk about that today. That's for a future meeting. What we are talking about today is what can we do with the process? What should we do with the process? And I think Maytac would like us to vote today on what will we do with the process. The process will run at the next board meeting when we actually have these hearings. The hearings will be run very formally. I've been working away in the background with Maytac and Harvey and Roberto to make sure I understand my responsibilities as the chairman. Final thought before I turn over to Maytac. There are times when boards should not agree. We have a very high function board. We usually agree because we're smart folks and we're well prepared. In my world, in startup companies, there are two times where you don't want the board to agree. There are decisions that are of such importance that it would be unusual to everybody agree. One is when you replace a CEO, basically fire a CEO. If you get that decision wrong, it can destroy a company. And the other one is when you go to sell a company, because some people want to say, no, let's wait to sell it, it'll be worth more. And some people say, no, I think that value is going to decline. And in those meetings, we really debate and really struggle. We have a vote. It's never 100%. It's never unanimous. Then we all go out and have a beer and pat ourselves on the back for disagreeing but reaching consensus. I pretty much guarantee I think that will be the case here, and for reasons Maytac will probably point out shortly, that we will not all agree on what we should do and therefore will do after a motion's made and voted at the next meeting in terms of how we treat these people that have committed felonies. And I think that's good. So as we all prepare hard for that next meeting by reading all the materials Maytac's already sent out and will send out, it's okay to come up with a harsher or a more lenient decision. I don't think we're all going to agree. Over to you, Maytac. By the way, Maytac, first-rate job on all these materials. I really enjoyed reading everything. Over to you, Maytac.
Well, thank you so much for the kind words, Chair Lanza. One thing I want to do before we start out, I know we've got the two items put together for items 3B as well as 3D, but I want to keep them separate and distinct because I don't want a conflation of the issues that we're discussing today. On one hand, the felony forfeiture provisions that are grant the authority to the board, there are two things to consider. One is the procedural due process, which is the how things come to the board. It is strictly the procedure and not the substantive application of the law. And that's related to item 3B, which is the proposed due process policy and procedures of how we are going to provide notice, a fair opportunity for these members to come before the board. This is strictly procedure. It has nothing to do with the substantive application of the law. Now that's in bucket 1. The second issue before the board that I am going to present today has to do with the substantive application of the law. That means how the board will exercise its discretion once the matter has come before the board. So think about it in 2 phases. One phase is how the case leads up to the board and the procedures that ORS and this board will take to afford minimum due process procedurally for the members, which is represented in our proposed policy. And the second issue would be the substantive application of the law, which would be the board's exercise of discretion. So please keep those 2 concepts distinct in your mind while I go through my presentation. The first issue, I'm going to pull up my screen and share. So please let me know if you can see this.
Yeah, we've got it, Maytech. Thanks.
Okay, perfect. So the City Council has had on its books since 1916 a forfeiture provision of pension retirement allowances for members of this plan who are convicted of treason or a felony. And so this provision has been in the city charter since 1916. Now the City Council has delegated authority to this board to determine whether and how to cancel and terminate retirement allowances for members who are convicted of a felony or commit treason. That delegated authority is found in the San Jose Municipal Code provisions. There are 2 provisions in the San Jose Municipal Code that grant this board the authority to do that. One is related to service retirements, and the other is for those who retire on disability. So I'm just scrolling down so you can see the 2 provisions. The provision related to the service retirement cancellation and termination for members who commit a felony or convicted of a felony or commit treason is found at San Jose Municipal Code 3.36.830. And this is the full text of the provision. So you can see here, it provides the board discretion, and it tells you how to deal with survivor and death benefits. And it also provides how the board shall deal with spouses and minor children. So this is the scope of the delegated authority to this board. But as you see here in the text of the San Jose Municipal Code, it says nothing to do on what due process procedurally these members are owed. It's completely silent on that. Now, I'm going to turn down to the disability retirement calculation and termination provision, which is largely identical to the service connected or the service retirement provision, with the only difference being that it's for disability retirement benefits. As again, you'll see here, it provides this board sole discretion to determine whether to cancel or terminate. And it also tells us what to do with survivor benefits and death benefits. And it also tells us what to do about payments to spouse and minor children. These things are delineated already substantively in the San Jose Municipal Code. But what you'll see again here is that nowhere in the San Jose Municipal Code does it speak to the procedural due process of how this board should deal with these cases. Now, the one thing that I would like to note for you all is that California courts have long held that public retirement boards must afford due process, even if the statute is silent. The most recent case that addressed this was the Hipshire case, which was decided, I believe, in 2020. In the Hipshire, the court looked at the PEPRA pension forfeiture statute. And in Hipshire, this was the summary of the facts. Is that the member was a firefighter, he was running a gambling ring, he had a felony conviction for doing that, and Lacera automatically forfeited his pension without a notice or an opportunity to be heard. They just did it automatically. The case was then litigated. The member appealed, as well as his association. And the retirement board argued both at the trial court and the appellate court that no due process was required procedurally because the statute was silent on it and did not require it. The Court of Appeal determined that no, that's not right. Regardless of whether or not the statute provides and explains how the due process will occur, the retirement board is required to provide procedural due process because of the nature of the property interest at stake, which is a retirement, a public retirement allowance. And so similar to the PEPRA felony forfeiture statute for the forfeiture of pension benefits, we are in a similar situation. Our municipal code does not say anything about how we are to provide notice and an opportunity to be heard. And so that's what our recommended policy here seeks to do. And just to put a finer point on what is procedural due process. Now, I mentioned before that there's two parts. There's a procedural part, and then there is the substantive application. For the procedural part, the procedures are focused on the mechanisms of how matters come before the board. So it's how these things are presented to you. And so the required components of procedural due process are twofold. One, that there's adequate notice to the member that this is going on. And two, the adequate notice to the member that the board intends to consider the application of these cancellation and termination provisions to the retirement benefits, and two, to provide the member a right to be heard to come before the board and make their case before the board makes its determination. So what our policy seeks to do is to provide the floor for these members to guarantee them, all members, do procedural due process, given that the statute is silent. We want to give assurances to our members that we will provide them procedural due process. Now here you'll see here as Exhibit 4 to the backup materials that I've provided to the board is the version that was proposed to the governance committee on February 3rd, 2022. This was the version that the governance committee considered at their meeting. And then the governance committee made slight modifications to that policy and approved it by majority vote. I'm sorry, unanimous vote. And so the changes that the governance committee made to the proposed policies are reflected in red line here. As you'll see, they added in language for notice to any affected beneficiary of the member to provide them the beneficiary notice as well, that this procedure is going to occur for the board to consider whether or not to apply the San Jose Municipal Code's cancellation and termination provisions to a member who's been convicted of a felony or commits treason. So you'll see here the changes in orange, adding in affected beneficiary to allow them to participate. And this was the version that was recommended to this board for adoption at the March 3rd meeting. I understand at the March 3rd meeting of this board, we did not actually take a look at this. So I'm showing this again just for you guys to take a look to see what was changed. And lastly, between March 3rd and now, we as Plan Council took another look at the policy. And so as this is the policy here, which is at Exhibit 6 of the materials I've submitted to you, is the policy that Plan Council is recommending to the board for adoption. Now here you'll see the recitals, which state that the San Jose Municipal Charter or the San Jose Charter provides this forfeiture provision, the 2 San Jose Municipal Code that grants the board the authority, and that this policy seeks to add in the procedural due process guidelines for members who fall within these 2 statutes. Now, as you'll see here, we provide written notice to the member and any affected beneficiary of the member to the extent locatable within at least 40 days of advance notice. That gives them sufficient time to find counsel if they so wish to and prepare their case. The reason why Plan Council has added into the extent locatable is that my understanding from ORS is that we do not collect beneficiary contact information. And so it may prove difficult to provide notice to beneficiaries of the member if we don't already have that information on record. And another change that we have here is that instead of having the plan and the member provide information about whether or not to apply the forfeiture provisions from the San Jose Municipal Code, we have added in to allow the city and other interested parties to present at the discretion of the board. This would include any bargaining units, retiree associations, and the like to come and discuss and present their views on the matters at stake. It also provides the board the power to subpoena anyone they believe is useful for the determination of whether to apply it. It discusses issues with rules of evidence. It states that the proceeding shall occur in publicly agendized meetings, and that it should be video and audio recorded stenographically for the preservation of the record. And the board chair or its designee, should the board chair not be available, shall preside over the proceeding. Once the board has made a determination, we have an appeal provision. The member, should we apply the provision to the member, shall have the right to appeal the decision in the Superior Court under a CCP 1085 writ. And so this is the policy that's being put forth before this board for adoption. This policy, like I said before, is recommended in light of the rulings in Hipshire that require a minimum floor due process, procedural due process of 1, notice to be heard, notice, and 2, right to be heard. With that, I open the floor for questions.
Thanks, Maytak. So as Maytak said, we're taking this in 2 parts. This is the earlier part, process, not what we're actually going to do to these folks, but what can we do in terms of procedure next month? What should we do? Maytak suggestions here in terms of procedure. And if we approve this, that is what we will do in terms of procedure. So floor is open. Any trustees want to jump in?
Yeah, Drew, this is Franco.
Thanks, Franco. Go ahead.
I just want to make a comment. In looking at this policy and trying to put myself as someone who would be going through it, I'm not sure that the 45 days, and I understand it says at least 45 days, I'm not sure that that's necessarily sufficient time. Someone were to get this, they'd have to process it. My guess is they'd probably make an appointment with one of the executives at the POA, come down, talk to them, get recommendations on attorney, get a hold of an attorney, have the attorney review the documents, and then have to work with the attorney in their schedule. I don't know that 45 days is necessarily going to be enough if someone or the entity on the board is pushing it. I'm thinking more like a 90-day.
So Franco, is that so there's 2 things going on here, right? There's the generic rules that a board 10 years from now may pick up, and that probably should be 90. And then there's this particular case. Would you recommend 90 days for this particular case?
No, I'm thinking in general for the policy. 10, 12 years from now, you've got some people on a board who maybe are anti one organization, whether it's Local 230 or POA, and they're pushing it because they don't like it. I don't know what's going to happen. I'm just thinking in process, if 45 is really enough, if the board were to push it.
Well, let me speak to Franco's comment, Chair Lanza, if I may.
Yeah.
So for the 2 members that we are considering for the May meeting, they have had notice since last October. So the notice provisions, we've already been dealing with these 2 members' council. They have 2 councils that they have retained. In terms of, so the only procedures that we would be applying for that would be in the actual proceeding section. But I do hear what Franco or Chair Votto is saying is that at least 45 days is maybe insufficient. 90 days may be a more favorable measure to provide the notice. To the extent the member seeks a continuance when they retain counsel or need more time to collect their materials, more likely than not, plan counsel will grant them that extension out of due process, because we want them to be able to retain counsel and adequately represent themselves at the proceeding before the board. But either way, 45 or 90 days, it works to satisfy.
So for this particular case, Maytak, it says there and any effective beneficiary. Have they been notified too many months ago?
Well, for these two, I want to be careful here because I don't
Yeah.
want to blur what and have any ex parte communications with this board without their
Okay.
present. So let's stick with the particular topic here, which is just the procedural due process policy before this board moving forward. Moving forward.
Tech, just procedurally, then we might say, let's accept this and come back next month with something for the future that says 90. We could do that, right?
I'm sorry, can you restate the question?
The motion here might be, let's accept this as is with 45. And oh, by the way, Maytag, come back in June or July with a version of this where you've changed 45 to 90 for the future.
No, what we would do here today would
Yeah.
be to approve, if the board so chooses, to approve
Yeah.
this due process policy with the modification that the 45 days would be 90.
Oh, so then but then okay, floor's open. This is a minor detail. Floor's open. Any trustees want to jump in besides?
Yeah,
Frank?
Mr. Chair.
Yeah, jump in, Dick.
Yeah, and everybody just relax for a minute when I ask these questions, because it's like the chicken and egg. You know, I've been on the board for like 24 years, 12 active, and now this, and there's nobody that I believe is more fair than the chair we have now, and we have a great board of trustees. I have no problem. But the first question that comes to me, to the city council, is this still needed? I don't know. Did we ask those questions? I'm asking for a legal opinion. You're saying, well, you've been delegated, there is no recourse. Because do we do the same thing for farmers, pharmacists, doctors, laborers? So why is police and fire being pointed out? Is this still needed? If it is and there's no recourse, then fine, we'll deal with it. I really like what Maytag and Harvey's doing here. I think it's going to be a fair process. I think Franco's got a good point. But the first question that comes to my mind, why is firefighters and police officers have a double standard? Is this a state code because we're a private system? So that's the first thing that comes to my mind. Have we considered asking the city council, is this still needed? Because the worst scenario would be, does it become political? I believe with this board, it would not, and it'd probably be a better process than have a city council deal with it. So those are just things that come to my mind. Being a member for 33 years, being very active, that's just a common sense thing that I think most of the retirees and present members would be asking, is it still needed? That's the first thing.
Yeah, and if I may respond to Trustee Santos.
Yeah, good. Jump in, Maytag.
So it is a good point. I will say the San Jose Municipal Code does not delegate authority similar to this to the federated board. So the city council, for at least for federated members, retains the authority to determine and apply however they will under the city charter any pension forfeiture provisions. This board is unique in the sense that the city council has delegated that authority to the board. Now, given that on the question of whether it's needed or not, that's a larger policy question, but as the law currently stands and as the San Jose Municipal Code is currently written, that authority is delegated solely to this board. And so if the matter does arise and is presented to the board and the board has knowledge of it, the board should, using Chair Lanza's language here, consider it. It does not mean it has to apply it, but at a minimum should consider it.
See, that's why it's still not an answer. The issue is, to me, I would say we write to the city council asking, is this something that's the municipal code? Do you want to change this? Do you want to continue with it? That would be the first thing, because it may be antiquated. It shouldn't be done. And then today we start talking about the word treason and felonies. And then what may be a felony in 1960 is not a felony in 2022. And one could be more severe. There's many questions that come up. I'm just like all of you. I just want to see a fair process. But again, I'm going to ask that same question. How do we know it's needed in the governing board of this city? Do they really want to continue with this? Because they have the right to change the municipal code.
Yes,
I'm not trying to not do my responsibilities, because again, If it is going to stay, then I believe the board we have is a really fair board and will do a good job. But
So
this goes back to the chicken and egg. Is it
So,
really needed?
Dick, I've struggled with that myself, and here's how I kind of look at it. Maybe Maytak, you can correct me. We have a contract, and disability committees, for example, we have a contract with folks. If you apply for a disability, the contract says you really are disabled, and you're telling us the truth. We have a contractual agreement with our policemen and firefighters. It's in the code that they will not commit a felony. And then, as Maytak says, when they do break that contract, our board has the right to figure out if we want to do something about it. Now, I agree with you that maybe the city should modify this, but I think that's not our board's job. We try to stay out of the middle of these things. I would have no problem if the unions want to go to the city and say, hey, this is a little strange, a little harsh. Why don't you change it? I wouldn't weigh in either way. But just like a disability, we have a contract with all of our policemen and firemen, all of our members, and these guys broke that contract. And I think just like people who fake a disability, I think this is a big deal. Now, whether we will do anything to them, again, is up for another meeting. That's a subsequent thing. But I think we should, just like remember that guy on the Ellen show, disability, we heard that. And I think we should hear this as well. Does that answer the question, Dick?
Well, I mean, you're giving a point of view. And again, I rather question the people who make the laws in our city and say, do you still want this on the books? I have no problem dealing with it. I understand my fiduciary responsibility.
Yeah.
And I take those very seriously along with you. One more time, I have no problem with the board and what we're doing. It would be a fine job. But I question, why does police and fire have to have double standards when many workers don't have to do this? So is it really necessary? Does the council want to continue with this? That's all I'm questioning.
Well, so I would ask you, let me just ask you a direct question, Maytak. You know, we tried to stay out of stuff between our policemen and firemen in the city, but we are in this because it's in the code. Do we have any right to play in the question Dick's asking?
You know, there's a case out there called Lockyer. It was a city and county of San Francisco and Lockyer. In that case, Mayor Gavin Newsom refused to, if you can recall, there's Prop 8 a number of years ago that prohibited the marriage of the same-sex couples. And so Gavin Newsom said that law was unconstitutional. I'm not going to apply it in my jurisdiction. That case went all the way up to the California Supreme Court. The California Supreme Court says, if the law is currently on the books, the administrative agency must follow the laws that are currently in play. Now, I understand there's a question of whether or not the city council should go back and amend the provisions. This policy has no bearing on what the city council may or may not do. We have no authority over the city council. What this policy here seeks to do is to provide the floor of due process in absence of any changes currently to the San Jose Municipal Code. So until the city council revisits these two San Jose Municipal Code provisions, we still need to do something for these members and to guarantee their due process. And this policy tries to seek to do that in the interim period, if that makes sense.
Yeah, thank you, Maytag. That does make sense to me. I understand that. I was just questioning the political part of it. But if, like you said, until the city council reacts differently, here's what we have to do. So I do understand that. And I'm really proud to be part of this process because I believe that, again, one more time, the chair and the board we have here will do a fine job, and our legal counsel. So thank you.
Thanks, Dick. I'm sure I speak from ATAC as well. We appreciate the compliments. Ray, I see you have your hand up, but first, hey, Dave, I see you got yours, Dave. Why don't you jump in first?
Thanks, Drew. Just to Trustee Santos's point, the POA does have a meet and confer set up with the city to discuss the applicability of these two statutes. So we will be discussing that further. Having one other comment and question from Maytak from the due process part. On the page 1 under purpose of policy, it says that if convicted of felony or treason, then any portion of that member's retirement allowance may be canceled or terminated. If you go under the muni codes, it doesn't say anything about a reduction. It says that has the any or all disability retirements. That any or all, is that the portion that allows us to reduce
Yes.
it versus cancel?
Correct.
Okay,
Any
that
or
was my
all is how, right. So it's not an automatic forfeiture. The question of the measure of the requisite or commensurate reduction of the benefits is within the board's discretion.
Okay, thank you. And the POA has had a chance to review the due process, and we like what we see so far, simply for the due process setting up, especially for the next upcoming May 5th.
Yeah, and hey, Dave, I think I speak for Maytag and Harvey. Maytag has counseled me numerous times, Drew, let's get this right. Let's do this really perfectly. So we're not embroiled in some appellate court and Supreme Court. So if the POA has any issues at all, Dave, reach out to Maytag and Harvey right away.
We definitely will. Thank you.
Great. The floor's open. Any other trustees want to weigh in?
Yeah, hi, this is Howard. I have just a general question, and with respect to other municipalities, how have they handled this? And to Trustee Santos's point, do they also specifically have these types of restrictions or rules with respect to police and fire as well? So I guess I have two questions. One, how do other municipalities do that, and how do they also handle police and fire?
I don't know off top all the municipalities in terms of what they have in terms of felony forfeiture. I can speak to the state provisions. The way they have it there is guided by HIPSHR, that, like I said, the state provisions for forfeiture of pension benefits do not specify due process. And so for those systems, they follow the letter of the law stated in the HIPSHR case. Now that had a different statute, that was a pepper version of the statute, but the same principles here apply. We need to provide, at a very minimum, adequate notice to the member that we are considering the application of the provision. And number two, that we give them a sufficient opportunity to be heard before the board takes any determination on their benefits.
Okay, all right, thank you, Maytag.
Thanks. Is floor still open, trustees? Any more comments?
Yeah, Drew, this is Andrew.
Yeah, great. Go ahead, Andrew.
No, I just wanted to thank, Council Maytag and Harvey and everybody that's been working diligently on this policy. I think everything in here, I think, makes sense. I like everything, including the revision that Franco's recommended, changing from 45 to 90 days. I could support that. But anyways, I want to just thank everybody.
Any other trustees want to weigh in? If not, floor's open to public. Ray, go ahead. You got your hand up. Jump in, Ray.
Yeah, hi. Thanks, Drew. Ray Storms here, President of San Jose Police Fire and Fire Retirees Association. I don't know if this question should be in this section or if it should be in 4D. And it has to do with who is eligible for this. I looked at the PEPRA, and basically it said you had to be employed and not retired. Or wait, you had to commit the crime prior to retiring, is the way I read it. So I'm not sure if this is supposed to be after. So if you've been retired, if you retired and then you committed a felony later on, that doesn't count. Is that correct?
That question's more suited for our discussion in item 4D, because that's a question of substantive application of the law. Here we're just considering the procedures. So I will.
Then I'll hold my question until the next part.
Yeah, thank you so much.
Thank you so much.
No, that's fine, Ray. It's a gray line. Any other members of the public?
Say that again?
Any other comments from the public? Floor is open. Anybody want to jump in? If not, hey, Maytag, stop sharing the screen and I'll put my little thingy up.
Okay, let me see. How do I stop doing this? Okay.
Let me see if I can share. Here we go. Oh gosh. Hey, can you guys give me sharing privileges? Linda, it's saying only the host can share. Oh, here it is. Thanks. Hang on. Let's see. Here we go. Can you guys see that?
Yes,
Is that showing? Oh, great. So here's my point. Look, Maytek's right. Right now, we're talking about process. Maytek has told us what we can do. She suggested very explicitly what we should do. And Franco's got a good suggestion for a change that Maytek thinks makes sense. So we can vote right now to say, Will, I put it in your May meeting because who knows, Dave, Franco, Maytek may come back in a month before the hearing and say, hey, we talked to council, we talked to other folks, want to make one or two more changes to process, and that's fine. And then the decision, which Maytek's now gonna loop into next, right? That's all next month. And Maytek is gonna start today. I put this in the unit color blue. Maytek's gonna start us today by opening up what we can do, right? And then when we meet next month, we will be very explicit on how we should deliberate over what we should do. And then, of course, we may or may not next meeting reach a motion of what we will do in terms of impacting their pensions. So, Franco, do you want to make the motion to accept the process piece with the 90-day change? Do you want to go and make that motion, Franco?
Yeah, I'll move that we accept the language with the amendment that it's a 90-day minimum notification period.
I'll second that motion as chair. Is there any comment either from anybody on this call or public, anybody? If not, let's go around. Andrew?
Drew, may I?
Oh, jump in, Harvey, absolutely.
Comment.
Yes.
Just for clarification on the chart that you put up.
Yeah.
For the process under will, the will would actually be today, the April meeting, not the May meeting.
Yes, good point, Harvey. But as I said, it wouldn't surprise me if we come back in 30 days and you and Maytek said, hey, we've looked at it and there's a word or two we want to change, and we could do that, right?
Well, yeah, the board always has the ability to do that.
Yeah,
so that's fine. I just want to make it clear
right.
that
That's why I put in green. That's today.
Yeah. And under decision, under the can, what can be done, that's also going to be discussed. That's the next item at today's April meeting, not May.
Yeah, good point, Harvey. I put May meeting here, and again, in a strange color to say, we don't know yet. There may be a formal document that outlines can that we want to accept and approve, and we don't know that yet, do we?
Well, we don't know that. We're anticipating that.
Go ahead. I'm sorry. Go ahead, Harvey.
We're anticipating that at the May meeting, the should and will be discussed with regard to two of the individuals who have been in the queue on this since October. We have notified them and reached agreement with them that their matters will be presented to the board for consideration of should and will.
Member. And in the instance that we do apply it to the member, allow the spouse or the dependent minor to file an application to continue to receive those benefits. So it would be a bifurcated proceeding with regard to the spouse if they so choose to want to come forward and seek continuation of those benefits. Now, the municipal code also provides specifically what to do about survivor benefits and death benefits. In the provision, it provides that survivor benefits and death benefits are unaffected by the forfeiture as applied to, are unaffected if the board decides to apply the forfeiture to the member, if those benefits would otherwise be payable. So these are the general contours dictated by the pure text of the San Jose Municipal Code with regard to service retirement allowances. Now, there's, like I mentioned before as well, there is also a provision for disability retirement allowances. The provision is identical to the service retirement allowances, except for it applies to disability retirements, and it provides the same discretionary authority and text regarding what to do about a spouse or dependent minor and what to do about survivorship benefits, survivor benefits, or death benefits. So the board's discretion is not unbridled. It's guided by existing case law from the courts. So the existing case law from court decisions more or less provide the guardrails for this board's exercise of discretion. So here are a couple things that come out from the case law. These are the guardrails. One, appeasing public opinion alone is insufficient justification. So here's an example. There is a crime that was done and the public is really upset about it. The board cannot just decide to apply the forfeiture as out of anger. There must be a reasonable justification for the application. So just appeasing the public opinion alone is insufficient. Another thing to be mindful of is that pensions are awarded for faithful and conscientious service. The forfeiture is appropriate for a breach of public trust. This is a theory of a pension consideration that the courts have upheld, that for pensions that violate faithful and conscientious service, the forfeiture for the breach of trust is appropriate. Another thing to keep in mind in terms of guardrails set by case law is that the felonious or treasonous act must occur before retirement. So this goes to Mr. Storm's question earlier today, which is that what is the timing of things here? So to put a finer point on it, there are three key time periods or three key markers in time that the board must take into consideration. One is when the felonious or treasonous conduct alone occurred. Two is when the member's retirement. And when I say retirement, it's not when you submit your application, it's when the board votes to retire the member, the effective retirement date. I'm sorry, not the effective retirement date, when the board retires the member. And three is the conviction. So it may be a situation where you commit felonious or treasonous acts before you retire, but you didn't get caught until after you retire. That sort of conduct is subject to the board's discretion under the San Jose Municipal Code. Now, take another example to demonstrate the flip side of things. Say the felonious or treasonous conduct occurred after the member is in retirement status. That scenario, the board is without authority to apply the San Jose Municipal Code provisions to that member, because the California Supreme Court has long held that if a member is already in retirement and commits a felony going forward after the date of retirement, that is not fair game. So there's three things to keep in mind. And I think the key ones to consider are: when did the felonious or treasonous acts occur, and what is the retirement date? So you measure those together. Another key consideration for the board is to determine whether it will return some or all of the members' contributions if it determines that it will forfeit any portion of their benefits. One thing to keep in mind with that is, with our San Jose Municipal Code provision for survivor and death benefits, it provides that those benefits are unaffected by any sort of forfeiture. So should the board decide to forfeit benefits, we would still need to consider how we will make up in funding to fund those benefits. And for a point of comparison, the California legislature has passed the Public Employees Pension Reform Act of 2013, known as PEPRA, for those less familiar with the law. And so the California courts have consistently held that the PEPRA pension forfeiture provisions are constitutional. And so the PEPRA pension forfeiture provisions provides a useful guidance for the board's exercise of discretion. And though one thing I would caution the board is that the PEPRA provisions are not binding, but they are persuasive authority. And so take that into consideration. You're not bound by the law of PEPRA, but it provides a useful guide. So here are the key provisions for the PEPRA forfeiture provisions. One is the type of conviction. In the PEPRA felony forfeiture law, it provides for the specific type of qualifying conviction. So it limits the convictions that the board falls within the board's jurisdictions to those that are job related and involve conduct arising out of in the performance of the member's official duties. Another key PEPRA forfeiture provision is that it provides for the specific forfeiture period. It provides that the forfeited portion of the member's retirement allowance should be commensurate with the felonious conduct that the member was convicted. And it provides that the forfeiture period be from the earliest date of the commission of the convicted felony through the conviction date. So that's the period of time that if the member accrued any sort of service credits would be forfeited in their pension calculation.
Let me interrupt for just one moment to give the board an example of those two, the type of job-related convictions and the forfeiture period to bring it home. There are two cases that come to mind, both firefighters. This was the Hipshire case. And in Hipshire, the firefighter was running a gambling ring out of the firehouse. And the courts decided that that was job related and involved conduct in the performance of his official duties. And it went on for about 8 years, I think. And so the forfeiture period was that period that he was committing felonies that he was later convicted for, while he should have been giving honest services to the County of Los Angeles. The other was the Wilmot case that Maytag has talked about, and we were involved in for the pension system on that one. Wilmot was also a firefighter. Wilmot, for a period of 12 years, stole property, guns, axes, equipment, kitchen utensils, any number of things. For 12 years, he stole property out of the firehouse that he was assigned to. The court again found that that was a job-related felony and involved conduct where he should have been giving honest services in exchange for his compensation. And it took place over a period of 12 years. And so he lost the value of the service of those 12 years as part of his years of service that went into calculating his pension benefit. So those are two recent key examples of what we're talking about when we talk about what is the nature of the conviction? Was it related to job, or did it arise out of something totally unconnected with the job? And what was the period during which they were employed that the felonious activity took place during? Was it a year? Was it 2 years? Was it 4 years? Those are the factors that we're talking about in the first two bullet points on this slide. Thanks, Maytag.
Yeah, and to reiterate Harvey's point here, the type of convictions, although the PEPRA statute itself makes fairly clear that the conviction must be job related and involve conduct arising out of or in the performance of their official duties, the job relatedness issue is often a key issue that's litigated in these cases. So for example, we had another case called Bustamante, where it was a sexual harassment case where it was off hours, but on property premises. And so that issue is often litigated and is within the board's discretion to determine whether or not for public pension boards governed under PEPRA to determine whether or not that conviction was job related. That's one of the key factual findings that the board must make. So moving on here to another key provision in the text of the PEPRA statute is refund of member contributions. Unlike our provisions in the San Jose Municipal Code, that's completely silent on whether and how to deal with member contributions should the board decide to forfeit. Contrary to that, the PEPRA statute provides very explicit terms of what to do. Under the PEPRA provisions, the employee contributions collected for the forfeited years of service are refunded to the member, and any amount of funds returned to the member shall be transferred to an account of the member in a manner consistent with the Internal Revenue Code. Another key provision of PEPRA stated in its actual text of the statute is that a reduction in sentence or later expungement of the conviction does not affect the pension rights that were forfeited. the pension rights in terms of the service years remain forfeited, even if the member is later receives a reduction in sentence or has the felony or treason conviction expunged from their record. The only instance provided in the text of the Pepper statute that deals with returning any sort of unwinding any forfeited benefits is only upon the final reversal of a conviction, meaning the member must have received a final reversal of their felony conviction before the public retirement system can unwind any sort of forfeiture that they have applied. And so it provides that what to do with the redeposits, it recommends to the board to work with the actuaries to make sure that the return of contribution is actuarially sound, and to restore their benefits and what to do in that instance. And here is what I think in my mind are the required findings for the board's exercise of discretion. Think of these as threshold matters that the board must determine before it can go into any sort of discretionary considerations. The required findings are: one, that the member was indeed convicted of a felony or treason. It's not enough to be charged with a felony or charged with treason. It must be a conviction. So the board, before it can even exercise its discretion, must meet this first requirement. The second required finding, as I mentioned before, is related to the timing of the conduct. The convicted conduct must have occurred before the member attained retirement status. So anything the member did before he or she obtained retirement status is fair game. Anything that occurred after the member achieves retirement status is beyond the board's authority. And then if the board decides yes on both these two findings, that one, the member was convicted of a felony or treason and the convicted conduct occurred before retirement status, then the board can go into these discretionary considerations. The discretionary considerations that the board may consider are: one, faithful service while the member was employed by the city of San Jose; two, job relatedness, meaning the convicted felonious or treasonous conduct was during the course of the member's duties or service as an employee of the city of San Jose; three, equitable considerations such as the gravity of the felony or treasonous conduct, the passage of time, whether the member has served their punishment, the member's health and financial conditions, etc. This is not a full list of equitable considerations, but these are some of them that come to mind when I think about this issue. And four, whether all or a portion of the service or disability retirement allowance should be canceled and terminated, and effective as of what date. So this discretionary consideration goes to Trustee Wilson's question earlier today regarding, do we have to do all, a portion? What is the reduction? That's within the board's discretion. Five, whether to return member contributions, and if so, in what amount, and with or without interest. That's within the board's discretion to do. And six, how to fund survivor or death benefits that may be due if member contributions are returned. Now, as the San Jose Municipal Code provides that survivor and death benefits remain unaffected if otherwise payable. So if we take away the member contributions, we need and refund them, then we will need to figure out how we would fill that delta for funding is a consideration to take. The board's exercises discretion as applied to spouses and dependent minors. The San Jose Municipal Code provides express text on what to do in those circumstances and what standard the board shall apply. Again, the board has the discretion to continue to award a member's spouse and or dependent minor the forfeited benefits if two requirements must be met. One, the application is made to the board for such payment, and two, that the payment is required for the necessities of life for the spouse and or the minor dependent. So the standard for the board's exercise of discretion in that instance is the necessities of life. The board also has discretion whether to award the benefits if these two requirements are met. And that I am now opening up the floor for any discussions. Thank you for your patience.
Oh, sorry, I was on mute. So floor is open for trustees, Harvey, Roberta, to any questions. My reading of this, I've sent a few minutes, Maytag, is, oh, great, we have absolute authority. We can do anything we want, which probably makes our meeting next month a lot tougher. Any questions, comments from any of the trustees?
Drew, it's Andrew. I got a question.
Yeah.
Maytag, so back to slide 12, the last one that you discussed, and it actually sort of coincides with slide 5 in regards to what it talks about in the municipal code and what spouses could potentially get if these two criteria are met on slide 12. So my question is there a history or case study that talks about what the spouse would get? So let's say we say the person that committed the felony, and we are going to revoke their pension, but the spouse is going to get something. Are we talking about half of what the pension is, or their normal payment's going to be? Do we use the formula as if it was a survivor spouse? Is there any language or talk that delves into that?
No, is the answer, because the San Jose Municipal Code provides specifically that these are the two requirements. And so as far as I understand, there has been no a published case law that has applied this forfeiture provision at all. So there's no case law on whether or not and how to determine necessities of life, for example, as the standard under the San Jose Municipal Code. But that being said, how much, what formula, what the spouse and or dependent minor need is within the discretion of the board. So, and it would be based on the showing that the spouse or the dependent minor puts forward.
Okay, thank you.
Any other trustees? Harvey, Roberto, anybody staff on the way in, anything?
Mr. Chair, Dick Santos, just a comment. I've had these conversations in the past years with Harvey, and he's given me examples that he's been through and his knowledge. I sure appreciate it. And today, Maytag, thank you both for your due diligence. Prior to this meeting, I had a lot of tension and apprehension because I've never been involved with it in all the tenure that I have been on the board. But you've really helped me to be able to make better decisions because of the thorough research. So I really appreciate that very much. Thank you.
Thank you for the kind words.
Thank you, Dick. What we're trying to do here for the board is to give you the skeleton of what is possible to consider in exercising your judgment on these things. And the judgment is broad, but there are some guidance. At the time of any consideration, the hearing that we have to consider this, that's when the meat, the flesh and the muscle will be put on the skeleton. This is more of almost a checklist, if you will, of considerations that you're able to make and things to look for when the proceeding comes before you. And you can use this also to ask questions at that time of counsel and of the members and their counsel, so that you have a full picture of those, that skeleton elements that you want to consider. Part of this is also to demonstrate, remember, we're trying to demonstrate that the board is exercising its judgment dispassionately and fairly in an open process that is based on facts, not on passion. And so we're trying to give you the checklist of facts for you to consider and ask for and to explore at the time one of these things come before you. So I hope you find it useful in that regard. And if there are gaps, we'll help you fill in the gaps as process by which the board has been granted broad authority, but not unfettered authority. So we're going to keep you inside the chalk lines, but what you know, to torture the metaphor, what play you call is going to be based on the conditions on the field that you see them at the time. Hope that's helpful. Thanks.
Thanks, Harvey. You know, to pay a compliment back to you, Dick, you know, you've done such a great job running those disability committee meetings over all the years. And as I said earlier and before, this notion of due process is not something our board sees often, but it's something that Dick adheres to along with the help of Council Requeda at all the disability committee meetings. They are run, they can bring witnesses, they're given due notice and so on. So while it's felony forfeiture is new to us, due process, Dick, you've done such a good job with disability committee. I think we've got a good stage here on which to act. Any other trustees want to weigh in?
Actually, Chair Lanto, if I may respond, I just had an
Sure.
afterthought to Trustee Gardner's question. One thing that going back to the board's discretion, you know, there is no case law that has been published with regards to the spouse or the minor, or that how the board's exercise its discretion specifically under the San Jose Municipal Code to any members either. Now, one thing I will caution the board, going back to, I believe it was slide, here we go. Slide 4 is that whatever exercise of discretion the board does, any action the board takes will be judged under this abuse of discretion standard. So any sort of benefits provided or taken away must be supported with evidence. It must be supported based on evidence provided to the board and based on the record before the board. If it's not, then there may be room for an argument of abuse of discretion, that there's no evidentiary support for the board to make that determination.
Right.
So in the
and
example,
that's where you're going to spend a lot of your time over the next month, I assume, Maytac, is making sure we're lined up in that regard, right?
Right. And so with regard to the specific question of spouses and minors, with keeping in mind with evidentiary support, if we go back down to, I believe it was slide, 12, there must be evidence provided in the record before the board to determine the necessities of life for the spouse and or the minor, for the board to decide to exercise its discretion to continue to award public retirement benefits to the spouse or the minor, even if in the circumstance that it has applied the forfeiture to the member.
Now this, Maytac, this makes all sense, and I definitely appreciate what you and Harvey have done here and presented here. You know, as Harvey was saying, you know, this is just providing the skeleton, and we all know that each case is going to be completely different, and we have to take them independently. And so, if we're trying to put a lot of guardrails in, well, it's unfortunately we can't do that. But I think what you have provided here is, you know, some criteria that we have to, you know, jump over, and then other criteria to consider when making a decision. And I think this spells it out pretty well. So thank you.
This is Howard. Maytac and Harvey, thank you very much. This has been very educational and very comprehensive. Maytac, going back to that slide, which I thought was pretty important in terms of the criteria, which is evidentiary support. And then the other part that's mentioned there is that conforming to the procedures as required by law. So I guess my question here is, you mentioned the guardrails, you mentioned PEPRA and guidelines. Are guidelines the same thing as conforming to procedures required by law?
No, this part here, conform to procedures required by law, is the due process issues that we had addressed in item 3B earlier today. So the procedures here are procedural due process.
Okay, all right, got it. All right,
and then
in
terms of your other question, in terms of, you know, I think, tell me if I'm misunderstanding you, but for example, there's case law out there about PEPRA and what PEPRA means, and the law of PEPRA, for example, is binding. It's not binding on this board. It's discretionary. It could be persuasive authority that the board may consider.
Okay.
So even though it's a law out there, it's not binding on this board.
Okay, great. I understand. And I guess I'm not aware of the May meeting. Is there going to be a presentation of some sort of issue that's related to this?
There are two members that we have notified and been working with their counsel about the board's potential application of these two service retirement felony forfeiture provision. I'm not at liberty to speak of any more than that.
Oh, okay. I heard it during this conversation. I just wasn't aware of anything. Okay, thank you. I appreciate that.
Floor still open, trustees, staff, anybody else? If not, go ahead, Ray. I see you got your hand up. Jump in.
Hi, Ray Storms again. Thank you for the clarification, Ms. Chin and Mr. Lederman. Excellent job on what I see so far. My other question would be, how far back do you go? So let me explain. Somebody has committed a felony. You guys didn't know about it. They retire X amount of years ago, by 5 years, 10 years. Heck, I know one or two that are 20 years old. How far back do you take this? That's an issue.
So unlike the PEPRA statute, in the PEPRA statute, the employer has an affirmative duty to notify the Public Retirement Board of any felony that falls within the purview of the statute. The San Jose Municipal Code does not provide any sort of reporting requirement to the board of any sort of felony conviction. Now, in terms of how far back we go, I think that to the extent the board becomes aware of a felony conviction falling within the terms of the statute, it is incumbent on the board to consider that case. But the board is under no obligation to go back and create a project and do an investigation of cases in the past. Now, moving forward, the board may decide to take some sort of administrative action to gather information from new retirees, but that remains to be seen.
And what do you mean by new retirees?
So it may be that the board may consider, for example, including on the service retirement application, whether or not a member has been convicted of a felony. It may be that the city council decides that they want to institute a reporting obligation moving forward. I can't speak for the city council on what they are going to do in terms of gathering information now that this has been on everyone's radar. So I say it in general terms with that.
Okay.
Yeah.
Understood.
It's complicated, Ray, by the fact that there's no mechanism in place for ever notifying the board that it should exercise this authority. And so years could pass and it could be just happenstance that the board gets notice. And so that's what we're dealing with. And it may be that we can put in place as part of the retirement process going forward, that when people retire, they have to self-disclose whether they've ever been convicted of a felony. It's just part of the retirement process that the board has the authority to trigger.
Well, I know
we don't get notice right now there's no mechanism to notify the board and trigger this process. But it's certainly the length of time is one of those equitable considerations that the board can take account of when it's deciding whether it's fair and reasonable under the circumstances to forfeit someone's pension years into their retirement. Certainly that's within the board's authority to consider the evidence on that.
Yeah, you answered one of my questions earlier about that had to happen during your career prior to retiring. So that's going to put a lot of my retirees at ease in case they mess up later in life after they've retired. Then the other question, like I said, was how far back do you go?
Yeah.
I'm going to mention one thing that was said or written in the notes at the last meeting, and it was that the stakeholders should be involved or contacted. I forget how the wording was. Just to let you know, nobody ever contacted me after our meeting last month. I was not contacted for discussion or input. I just want to put that out there because if we're going to do these things and we make a statement that there's going to be contact, there should be. That's all. Not a problem. I don't know who should have or was supposed to, but if you go back to the notes, or it's in there. And I was kind of surprised that I hadn't heard anything, and I got on to look at the agenda. Knew it was coming. I knew it was coming this month, so I went through and looked at everything, looked at the prep work, and I appreciate all that work that you two did. It's really good, and there's just little tweaks that need to be done. And I understand we can't make it so rigid that there's no room for discretion, and I understand that. So thank you for your work. Much appreciated.
Thank you.
So one of the reasons I really like you, Ray, is you're a really smart guy. And that question is what's been weighing on my mind. And it's why I did that can, should, and will thing. You know, Ray, over the summer, it wouldn't surprise me, and I'm not saying real room, but it wouldn't surprise me if the board came back in the wake of the hearing and wrote down some guidelines around should. You know, we might decide, and I'm not saying will or won't, Ray, but we might decide, you know, I forget if Franco or Dave said, you know, if you got arrested for jaywalking when you were a 27-year-old 2-year cop, the board may, I'm saying, well, we may say, look, we're going to say for the future, we don't think the board should hear those cases in the future, or if it does hear them, it should be lenient, because again, as I keyed this up and it's Maytag shown, we have enormous authority here. And I think that means part of our responsibility should be to signal, and I think you're smart, Ray, how we'll use those authority. I don't know what these people have done this time. I don't know if it's jaywalking or murder. I haven't heard, right? But I think you're right, Ray. There's probably something coming in the future where we say how we'll use this great authority we've been given. It sort of goes back to Dick's question too. Makes sense, right, Ray?
Yes, it does.
Yeah, and we'll loop the members in, obviously, on that discussion. You know, if you hear from your members some of the concerns like you just said, I think it's relevant, because I could see a feeding frenzy starting in the wake of this, and nobody wants that. I don't know if Maytag or Harvey, you want to weigh in and tell me it's across the line, but that's my thinking.
Well, I think if it's well, here's one thing I want to make sure I make clear to the board. You know, when the matters come, these are complicated matters, and they're very fact intensive, and there's a lot at stake, but for the member. And so, you know, the board, when a matter comes before the board at a particular meeting, the board is not required to render a decision at that meeting. The board may consider it. If it needs further investigation, they can defer the matter, and the members can come back, and, you know, Plan Council can come back with any information or further investigation or legal research on an issue. It should not be a hasty procedure proceeding, excuse me, that the board should undertake.
Well, I'm sure what Maytag, when you write your memoirs in 20 years, you're going to point out this is how you spent the last 12 months of COVID, was working on this. Yeah. Floor's still open. There's no vote here, as Maytag said. Any more comments?
It looks like Matt Tuttle has his hand up.
Oh yeah, go ahead, jump in. If you want to just jump in, go ahead.
Great, thank you. So Matt Tuttle, I'm president with Local 230. What I'd like to bring up is more, not sure if it's kind of the right time, right place, and it's more of a hypothetical, but I think it's an issue that we're rapidly approaching in the fire service that may become a future concern for the retirement board. But currently, the state utilizes convict crews, so folks that are currently incarcerated on a variety of different charges some even including felonies. But there's been movement at the state level to create pathways for these individuals to get hired by full-time fire agencies once, upon their release. How that specifically is going to look in the future, that's anybody's guess. But I think the reality that we're starting to live in is, would we potentially have a felon that gets hired by the San Jose Fire Department in the future? And how would their retirement look? How would they go through the same type of procedure for review? There's a lot of different what ifs that you can throw into it, but the fact that we're kind of seeing it as a strong possibility moving forward, how would it get handled by the retirement board? So I think it's more of a throwing it out there and making you all aware of it, rather than a demand for an immediate answer or anything like that. So whether there's case law on this or whether it has happened, I can't say for sure, since typically our background investigations are pretty stringent. But I just want to also just take the chance to thank you all, because this is not an easy undertaking to do it all. So thank you.
Thank you, Mr. Tuttle. In response to that, that sort of consideration, fact pattern would fall under discretionary considerations. And so one of the discretionary considerations is faithful service while employed with the city of San Jose. So if it was a felony that occurred before employment, that was totally unrelated to their employment period with the city of San Jose, the board may exercise its discretion to determine whether or not to grant or allow those years.
Yeah, sounds like that touches on what I just mentioned too. And, can we put out some guidelines? I'm not saying we'll ruin, but that's exactly the question where you might say, we're talking to these guys. We might hire them. Can you give us some assurances you're not going to come after them in future? And while we don't want to bind future boards, I think we can write some logical statements that our council says make sense, and we vote on, that future boards hopefully will take into account. There's always this dangerous thing. You never want to really bind a future board, but it's okay to give them wisdom from the past. I don't know, Harvey Maytag, I don't know if you want to weigh in on that.
Well, I want to be respectful of the city and the bargaining unit's authority. And so this is an area I think that if we were to seek clarity, I would defer to the bargaining units and the city's negotiations and any amendment to the municipal code to that effect.
Yeah, that's wise counsel.
I think we can fairly say that when the Supreme Court's reasoning behind not causing a forfeiture for something that took place after retirement, after employment, would apply here as well in the situation that Matt raises, which is, what about something that happened before retirement? I think the same reasoning in the Wallace decision from the Supreme Court that applied there to post-retirement would apply to pre-retirement as well. I'm not aware of any case that's come down on that, but how contrary would that be to the idea of a fresh start for someone who may have been convicted previously, to then saddle them with this threat that they get a fresh start with the city of San Jose and work in safety, and 20 years later, the benefit they thought they were going to earn is taken away from them. I wouldn't want to be the one handling that particular matter.
Yeah. Floor's still open. Anybody, public, trustees, anybody?
Yeah, Dick, this is Franco.
Oh, good, Franco.
Yeah, I just, I understand that it's going to be our responsibility here, but I think it's going to be very important for Local 230, the POA, and the Retirees Association to have some conversations amongst themselves and with the city, and then maybe present us with, some a guide or some, basic concepts on how they believe this should apply. And then that's really where we're gonna, begin to start discussing this stuff.
So are you going to drive that, Franco or Dave? Is that kind of under your purview?
It's already in process on our side.
Great.
I'd just follow up with Andrew, for Local 230, obviously, and then, we'll loop in Ray.
Well, yeah, you and I talked, Dave, and you and I briefed in San Diego about this, and boards are made of constituent representatives, and you guys represent our members. And so your voice in this discussion is significant. I suspect, we're representing the system. That's our fiduciary duty. You are too, but we're also, I guess, to some extent, we represent the citizens, the taxpayers. And so I think all these voices need to be heard, including, the voice of counsel for them. I think Maytag and Harvey done a great job of lining this up as let 1,000 flowers bloom, while also saying, but it's our fiduciary duty and we have great latitude for how we exercise it. I like that dichotomy, Maytag, that we're listening to everything but we're retaining the right to do as we will, right? Is that well said, Maytag?
That's under the current municipal code statute. So if the San Jose Municipal Code, as it currently is written, is that the board alone has the sole discretion in determining whether and how to apply the cancellation and termination of the of a member's retirement allowance based on convicted felony or treason. Now, like I mentioned earlier, this authority is delegated to the board by the San Jose Municipal Code. Should the unions in the city want to provide guidance on how the board should exercise its discretion, it will need to amend the municipal code provisions that govern this board, because as it stands now, the board has a sole discretion based on the language there on how it will exercise that discretion.
But you would say, Maytag, because it's so broad, we should listen to all voices at all times. Wouldn't you? You said that in one of your bullet points.
Yes, we can consider it. It's not binding, it's persuasive
Right.
information if the guidelines were to be provided. But if the guidelines were, for example, agreed to through bargaining negotiations and amended into the statute, then that would be a different conversation.
Yeah, that's well said.
I will point out that in the previous agenda item, the board approved the policy for the procedures of how to handle this. That policy allows any interested stakeholder to come forward during a proceeding and make their views known. So it's not
that was the bullet point.
It's a public meeting, and any constituency that wishes to weigh in on what they think is appropriate under the circumstances has that laid out for them specifically in the policy the board just adopted.
Great. Let's let those be the last words. We heard from Councilwoman Foley's office that she's traveling. So we've only got 3 items left, and they're all yours, Roberto. Why don't you go drive us through 4A, 4E, and 4F?
Thank you, guys. I'm going to stop sharing my screen.
Thank you, Mr. Chair. I'm going to start with my audit report. So let me just start with something that is very important to the police and fire retiree members. The Medicare Part B reimbursement project, which deadline was April 1st for eligible police and fire retirees to submit applications for reimbursement, came to an end, right? And then on April 1st, we received about 780 applications. About 600 of those have already been processed in the March and April payrolls. There are about 180 of those reimbursements left to be processed, which we expect them to be processed in the month of May. So if any of you trustees hear from a member that is waiting for the reimbursement, some are going to be coming through in April, the rest will be in May. Also wanted to let you know the quarterly newsletter is forthcoming. It should be going out in the next couple of weeks, and we are addressing A couple of issues. The newsletter addresses the most recent valuations and the evaluations audits, the investment market and the exposure to Russia, as well as the fact that we had, as an office, kick off a hybrid approach of having staff in the office 2 days a week. Obviously, we're going to continue keeping track of the pandemic. And although the office is actually closed at this point, we do open the door for members that come in from time to time. And of course, we continue our core services and encouraging members to make virtual appointments as much as possible. But again, we have staff at the office. In fact, Prabhu and I are taking our board meetings from the office every month. I suspect that this approach is going to continue for the time being. And then we're going to revisit this probably most likely in the month of May, and where we could then take in next steps to not only the hybrid approach with staff, but also the eventual opening for the office to the public, again, assuming that there are not new cases or increases COVID related. I also wanted to share the good news that we did have hire a new network technician that started working with us last month on March 21st. In addition, the IT manager interview process is continuing. I think at this point, we're hoping that we get into the end of the process, and we are obviously making a decision, wanting to make sure that we can reach out and hear from input from people outside the office on prior experience for the members or the potential candidates that we're thinking about. So I'm hoping that for the next meeting, I'll have news on our new IT manager. Unfortunately, in terms of personnel, we also just recently lost an account clerk in accounting who was running, among other things, making sure that paychecks went out for the retirees and the payroll for the office. So we are going to kick off that recruitment process soon. And in terms of personnel, lastly, we are welcoming 2 new benefit staff to the office with a very good experience, one of which actually have experience with the United Nations Pension Fund. So their name are Tracy Tanner and Tara Tran. It's not that we require that new employees' name and last name start with a T, but those are their names. And we welcome them and look forward to working with them. They are joining us next week at the office. I also wanted to share with you that the city revised the masking policy, and so the city has lifted the mandatory masking for employees and guests in facilities, although they strongly encourage them for employees and visitors indoors to wear them whenever possible, but it's not required. And I think that actually concludes. Oh, lastly wanted to mention to you that early in March, after your last board meeting, Prabhu and I attended the CalPERS General Assembly, and so did you, Chair. As a director with the CalPERS board, I was moderating a particular presentation at the Assembly, which had to do with, delegation to investment staff. And so we have members from various boards across the state and CIOs and a consultant to speak about the experience. And in terms of that, we had Prabhu Palani, our CIO, speaking on behalf of the San Jose experience, as well as you, Chair, Drew Lanza, spoke as a trustee at the conference. So again, I want to thank you both for taking the time to do that. And that actually concludes my comments. I'm happy to answer any questions about this update or any other questions that you may have, either you trustees or the public in general.
Let me jump in real quick, Roberto. Do you think we're going to be back in person for the May board meeting? Is that your read right now?
No, I do not. Actually, I defer to council, but I think, as you know, we have come to learn about Maytag's show, the Assembly Bill 361, that if once that's approved today, that would allow us, Maytag, if I misspeak here, please correct me. Once you approve that today, it would allow your board to have your May meeting virtually. Is that correct, Maytag?
That is correct.
Yes, and so I fully expect, unless something happens in the next 30 minutes, that the May meeting will be virtual. And actually, I did speak to council yesterday. I don't have any concrete decision on the matter, but from meetings that I have had at the city level, it looks, unless there are some strong changes coming from the state down to city government and other areas, it appears that it is likely that your board meetings will continue virtually through June and most likely come back in person in August. Again, I can't emphasize enough, that is my understanding right now. That's the way it looks. Obviously, we will keep you posted. But suffice to say that at least for your May meeting, once you approve AB 361 this morning, it will be a virtual meeting.
Well, let me ask you, Maytag, it would seem to me that holding the hearing in person would be better than doing it over Zoom. Do you have a thought on that?
Well, this has been pending for the members for quite some time. I do think we owe it to them to give them some sort of confirmation, either one way or the other. Having this looming over their head has been, understandably troublesome. It could be perceived as such. I've been working very closely with their council to meet and confer on dates that are available to council as well as the board. And given that the board takes recess in July, I do believe that having the meeting in May as agreed to through meet and confer with their council is appropriate. Now, regarding whether or not to meet in person at that May meeting really depends on how COVID behaves. I don't know for certain how it's behaving in Santa Clara County, but at least in New York, there is an uptick of COVID cases. So, I can't really tell you if it's safe or not to come back in May.
So, Maytag, would it make sense to postpone the decision on AB 361 or do it now and maybe countermand it with an in-person meeting? If we vote on AB 361, can we countermand it later?
Yeah, you can. AB 361 just provides you the election an option to utilize its abbreviated teleconferencing procedures. It does not require that you do this.
Right. All right, great. So we'll go ahead and vote on it on item 4F. So board members and public, plan both ways. We may be in person or we may be virtual. So leave yourself enough time to drive down to San Jose. It makes sense?
Yes, I just want to make sure that we understand if for some reason the board do elect to have this as a in-person meeting, I'm not sure that we are able to have it at the usual location at the city because they're sort of working on making some maintenance and doing some work. I think with understanding, and again, I can't speak for the city, that they may be coming to have person meetings in August. So there's a good chance that if we cannot meet at the city location, we will then have to meet at our offices. So, but again, I understand where you're coming from. I think from an administrative standpoint, I don't think it will make a difference whether it's virtual or in person, but I certainly respect the board's decision on whatever they would like to do. I also would like to know, I think, Maytag, you can correct me because I don't remember, not that I'm asking you to tell me the members' addresses, but are they close by that they can drive to San Jose with no problems, or they're far away?
That I'm not certain. I'm not certain where their current locations are. And in terms of the question of whether or not it should be in person or not at the May meeting, we do need to meet and confer with their council because I'm not sure what their comfort is for an in-person meeting. So far to date, we've only discussed Zoom, given the current state of the pandemic.
Yeah, I mean, Mr. Chair, we certainly will entertain whatever the board decision is. Obviously, that's what we're here for. But if I may respectfully, I would recommend that we consider proceeding on a Zoom approach,
Roberto?
and then change that if warranted and certainly if required. That would be my recommendation, but certainly I'm open to a different view.
Yeah. No, let's go ahead and do that, Roberto, unless the trustees want to weigh in. I will note that I'm on 8 or 9 boards now, and this is the last board that's not yet meeting in person. So, and in person is a little bit better. Hey, floor is open. Anybody have any questions on this issue or anything else for Roberto? Just jump in. Anybody? Public? Anybody? Go ahead and go on to 4E. Go ahead, Maytag.
Okay, go ahead. No, I was just checking. I was just checking to see if we went to item 4B.
Oh no, Pam sent us a note saying she's traveling. Her chief of staff did.
Oh, okay.
And we're in 4C and 4D. No, it's fine. You're fine.
Okay,
so over to
you want
4E. So yeah, we're good. Yeah, she said send her
Thank
regards.
you, Mr. Chair. So Michelle, if you be kind enough, see, that's what happens when you plan ahead. Thank you, Michelle. So this is a straightforward item.
Psychic assistance.
So the final audit of Grant Thornton on the contract is coming up. Is the June 30th, 2022. And so as you are aware, over time, we have spoken to your board about some of the requests by Grant Thornton on reasonable increases to the agreed contract amount. And it has been a work that is really, from management standpoint and from my personal standpoint, a balance, right? Where we certainly could hold their feet to the fire and ask them to do the work at the original amount. But I recognize that because of changes over the years, there have been an increase on their business. And while we have not agreed to their original request of increases in cost, I have again walked a fine line between making sure that we have a good business relationship, especially since years back, there were still quite a few years left on the contract, and this is going to be the final year. So here we are on with the contract, and given the increases that we have approved over the years, in order to be able to make their final payments for the audit work that is going to take place in June for the June 30th, 2022 audit, we need to come to your board and request an increase of about $50,000 to the latest balance of $500,000. Now, if you look at the memo, we don't need the full $50,000. We actually need just a little less than $40,000. But we're asking you an additional $50,000 in the event that anything comes up, so that we don't have to come back before your board. But rest assured that at this point, our intention is to only pay the amount that it is included in the contract and in the memo, up to, I believe, $37,000 and change. So I'm happy to answer any specific questions. I think the memo is pretty self-explanatory and straightforward, and it explains the need for the increases, or at least the explanation for the increases that I requested over the years. And with that, I'll turn it over to you, Mr. Chair, and I'm happy to answer any questions.
Thanks. Floor is open. Trustees Harvey, Maytag, any questions on this for Roberto? Anything from the public? If not, I'll entertain a motion to approve this.
Santos, approve.
Second. Do I have a second?
Second, Wilson.
Great. I've got a motion by Santos, second by Wilson. Let's go around the table. Andrew. Andrew, you there, buddy?
Aye.
Sunita.
Aye.
Howard.
Yes.
Eshfar.
Aye.
Dick,
Yes.
Franco,
Aye.
Dave,
Aye.
Mr. Chair Lanza, I vote aye as well. And in the words of my esteemed colleague, over to you, Maytac, for the Maytac show.
You guys, this may be one of the last Maytac shows there is, so enjoy every minute of it. So going to the comments earlier today, the materials that I've provided to you, as of today, the proclamation from the governor of the state of emergency for COVID-19 continues to be in place. And as of April 5th, the city council continues to recommend social distancing and has passed a resolution to that effect. So if this board decides to adopt those two factual findings by majority vote, it may elect to use the abbreviated teleconferencing procedures under AB 361 for the next 30 days, carrying you over to the May 7th meeting. I'm sorry, May 5th. Back to you, Chair Lanza.
Yeah, I'm jumping between windows, my iPad. So I forget Maytac. All I have to do right now is get someone to move to approve those findings, right?
That's correct.
I will move that we approve those findings. So I have a second for my motion.
Second by Santos.
I've got a motion by Lanza, a second by Santos. Go around, Andrew.
Aye.
Sunita.
Aye.
Howard.
Yes.
Eshvar.
Aye.
Dick.
Yes.
Franco.
Aye.
Dave. Chair Lanza, I vote aye. And then we'll do the committees after we adjourn this meeting, right, Maytac?
That's correct.
All right, great. All right, hang on, guys. Let me pull up the agenda again. Give me a sec here. Oops, hang on. Hang on. I'm somewhere in process here. Hey, go ahead, pull up the agenda, will you? For some reason, I can't pull up the attachment. Great. This is to announce service retirements of Brian P. McDonald, police officer, police department, effective April 16, 2022, with 26.07 years of service, and Vernon L. Todd, police officer, police department, effective April 30th, 2022, with 25.14 years of service. Do I have a motion to approve those two retirements?
Santos, yes.
I got a motion by Santos. Do I have a second?
Gardner, second.
Wilson.
I've got a motion by Santos, second by Gardner. Let's go around. Andrew, how do you vote?
Aye.
Sunita, how do you vote?
Aye.
Howard?
Yes.
Eshvar?
Aye.
Dick?
Yes.
Franco?
Aye.
And Dave?
Aye.
I vote aye as well. I don't know, anybody want to say anything about these folks?
Yeah, this is Wilson. I worked with both of them. They're both outstanding gentlemen. Mr. Officer McDonald actually happens to be a director on our POA board, and he will be sorely missed as he moves on to greener and greater pasture.
Thanks. Well said, Dave. Deferred vested Scott Morshi, police officer, police department, effective April 2nd, 2022, at 23.21 years service. Do I have a motion?
Motion by Santos to approve.
I got a motion by Santos. Do I have a second?
Gardner, second.
I got a second by Gardner. Let's go around. Andrew?
Aye.
Sunita? Sunita, you there?
Yeah, sorry about that. Yes.
That's fine. Howard?
Yes.
Eshvar?
Aye.
Dick?
Yes.
Franco?
Aye.
Dave?
Aye.
I'm Chair Lanza. I vote aye. Anything you want to say about this gentleman? That's okay. We have a good month. We only have one of our members who passed, and before he was able to enjoy 30 plus years of retirement. So announcing the death of Dwight R. Messimer, police sergeant, retired April 5th, 1989, died February 24, 2022. survivorship benefits to Renate Messmer's spouse. We'll now have a moment of silence. Thank you. Anybody want to make any comments about Mr. Messmer?
Yeah, this is Franco. I would just say that he retired 6 years before I got hired. That's a pretty good life in retirement, and condolences to his family.
Yeah, I'm in Austin because I've got a grandson. My daughter was born after he retired. God bless you, Mr. Messmer. On to committee reports, investment committee. Over to you, Ashfar.
So we've not had a meeting since the March meeting, Drew. So it's just this AB 360. So nothing to report.
Great. I'll note that we have the minutes from that special AB 361 meeting we received and file. Audit risk. Over to you, Sunita.
Yeah, same here. I think we have, besides the Maytag show, we haven't really had a meeting.
Great. Well, we poor Maytag. Forever after AB 361's we minutes the Maytag show. Note that we'll receive and file those minutes. Disability committee. Over to you, Dick. Oh, I'm sorry. Governance. Over to you, Franco.
Okay, I'm taking a look here. Are we doing the whole thing, or is this just we have nothing to report?
No. This is just there's nothing to report. You haven't met. We'll receive and file, and in a minute or two, we'll do the Maytag show for you.
Yeah, nothing to report.
Okay, great. Disability committee. Over to you, Dick.
Yeah, thank you, Mr. Chair. As you can see, we have the minutes there on the about the committee and attachments and the minutes, and so there's our next disability meeting has been canceled, so we're looking forward to May.
Great, thanks, Dick. We'll note that we got the minutes from the Feb. Hang on. You go get on me. Feb 3rd and Feb 7th meetings. JPC, over to you, Andrew.
So we did meet with the JPC early March. The main thing that we went over, so the previous ones, we were going over the CEO's performance process feedback. And last month, March, we started having the discussions on the CIO performance process. So attached, you'll see some revisions that have been made to it. That's about it. Roberto, do you have any additions?
No, other than obviously your joint personnel committee did approve these changes, and other than, for the most part, other than the letters from the CEO where a change to CIO is pretty similar on both cases. And I think that's what your committee has been working on. So again, this is just a fun information to the board. If you have had a chance to look at the information and review it, and you have any questions, I'm sure we'll be happy to address any specific issues. But the committee has been working diligently, meeting every month, and we are moving forward because this process will be implemented for the upcoming performance review process for your CEO and your CIO for the fiscal year ending June 30th, 2022. Thank you, Andrew.
Thank you, Roberto. And to carry on what Roberto was just saying, this will be implemented for this upcoming fiscal year evaluation, and the committee has already agreed that as we go through this process, if there's any tweaks that need to be made, please provide the feedback, and we will revisit it as a committee and make necessary changes if needed.
Great, thanks, Andrew. Let me note that we've received and filed the minutes of the Feb 4 meeting. Everybody stay online. We're wrapping up our meeting, but it'll be time for the Maytag show shortly. Any proposed agenda items? Anybody online? Yeah, go ahead.
If I may, there is an action item in subdivision D of 7.5, which is discussion and action to approve the performance evaluation revisions that the JPC has. Sorry, you cut out.
Right, Andrew, that's ongoing, isn't it? Oh, I'm sorry, I'm in a car. Andrew, that's ongoing. That's not done, ready for vote yet, is it?
Andrew, you are muted.
Thank you. Drew, we did approve and voted for that at the JPC meeting. So it's more, I guess, for the other trustees, if they have any questions or additions they want to, make, that we can make those or take those in consideration. Otherwise, just make a motion to approve what we have.
Yeah, thanks for catching that, Maytag. Does any trustees want to weigh in on this? Any public members? If not, go ahead and make the motion, Andrew.
Yeah, I'll go ahead and make a motion to approve the revisions to the performance evaluations for the CIO.
I'm on that committee. I'll make a second to that motion. Let's go around. Andrew?
Aye.
Sunita?
Aye.
Howard?
Yes.
Eshvar?
Aye.
Dick?
Yes.
Franco?
Aye.
Dave?
Aye.
Chair Lands, hey, thanks, Maytag, for keeping me honest. I really honestly appreciate it. That brings us near to the end. Any proposed agenda items? Anybody want to say anything?
Yeah, Mr.
Going
Chair.
once?
Mr.
Yeah, go ahead,
Chair,
Dick.
this is Dick
Yeah,
Santos.
good. Yeah.
Do you want me to call you offline about with their discussion about the issue we've been talking about in terms of back in 206 about a questionable expense account?
Yeah, I think we left that that you and I would grab lunch with Roberto after this meeting, and thanks for tickling me. I'll send that email out now, Dick. Thanks for reminding me.
Thank you.
Yep. Any other comments? Once, twice, thrice. We are adjourned, and now it is that time for the Maytag show. Over to you, Maytag.